I would like to call the meeting of the Wichita-Sedgwick County Board of Zoning Appeals to order. First item. You doing that? No, we're going to do them afterwards.
Kyle Kobe, Associate Planner. This is BZA 2017-50. It is a city case for variance for a side yard setback to accommodate a garage structure. And I'll just use the images here to kind of tell the story. Here's the site. It's on North Mount Carmel Avenue. This is the principal structure that you see here, and there's a previously existing garage present right here. Here's a site plan provided by the applicant. Basically what has happened is that the applicant has added onto the previously existing garage a carport that they then covered and turned into a garage. This garage is the extent of it goes to 2 feet from the adjacent property line, which is the minimum required setback is 6 feet, so this is projecting 4 feet into that required setback. Here is a Google Street View image that was taken. This is from a couple years ago, obviously before it was enclosed as a garage, but just to kind of give a sense of you can see the garage back here behind it as well as the structure itself. Here's a Google Earth aerial. Again, just so you can kind of get a better idea of the site itself. Here's the previously existing garage and the principal structure, and then here's where the carport was built. Here's the site from the street. This is looking north, so that the house is right over here. This is the driveway. This is directly across the street from that driveway. This is looking south on Mount Carmel. And then this is a view, here's the structure in question, and then here's the neighboring property right here. Staff is recommending approval based on previous cases that have been recommended for approval by this body. If this case were to be recommended for denial, the applicant would be required to remove the structure. We have a series of recommendations where, if approved, the applicant would need to, for example, have inspectors come out and evaluate the structure to make sure it is up to city codes. Any questions?
Questions for the presenter? Okay. Thank you. Anyone in the audience wish to speak on this matter? Yes, sir. Please come forward and state your name and address.
Shouldn't the applicant go first?
My name is Todd Harp.
I'm sorry.
Todd Harp.
Yeah, let me back up. Procedurally, I need the applicant to come forward first, and then I'll ask for comments. Are you the applicant?
No, I'm not.
Yeah. Would you? Yeah. Please sit down. And I did it wrong.
My name is Romaldo Lopez, and I'm representing RDX Rentals. And we Beverly sold the house 5 years ago, and the tenant started doing that addition. And then 5 years later, that's when the city came and started asking about the permit and everything that was done without the permit. And other than that, I don't have anything else, whether they leave it or we need to remove it. I'm here to do whatever I need to do. If we do stay, we were willing to, like he said, to bring the inspectors and make sure that we get it security and up to code. Now, keep in mind, it used to be a state box, 3 feet, and now they changed it into a 5 feet, I think. So if they enforce the step back, regulations, we don't have enough room to do anything. Thank you.
Thank you. Any questions for the applicant? Sir? Mr. Foster?
Looking at that picture there, the right side of the structure, I can't tell if it has guttering on it. Does it have guttering?
Yes.
And you happen to know, does that guttering have the downspouts? Are they directed onto the property to the right side there? What I'm getting at is I think we have a drainage issue here.
I cannot see it exactly, but if we had to put gutters and bring the water to outside on the front of our property, we'd be willing to do that.
Okay, that's what I want to confirm. Thank you.
Yes.
On the recommendations, number 3, it says that gutters and downspouts shall be added and it doesn't run off on adjacent property. So that's covered in the,
Requirements?
in the recommendations there.
Have you had any conversations with the neighbor to the next door?
Yeah, my understanding is that my tenant is still living there, and he have a good relation with the neighbor next door, and he said that he don't have any problem. That's all I know.
Any other questions for the applicant? Seeing none, thank you, sir.
Thank you.
Now, we will ask for comments from the audience.
My name's Todd Harp, and I own this piece of property next that they're talking about here. I told them when they were putting it up that it was too close. And then, he really didn't seem to care. So, but it was just a kind of a lean-to to begin with. And they did all this, most of this construction at night anyway, without a permit. And it is less than a foot from my property line now, currently. This fence here is my fence that you see. And it goes back right alongside that garage that they've put up. It's very substandard. I mean, it's just sheeting. There's no siding on this side towards the fence. It was running off forever. The guttering is something just this year they've put on, and it does kind of drain right there in my property. He's got a downspout there, a downsplash guard that drains. But it is, I mean, it's going to affect my property values quite a bit. I mean, I don't think any of you would want it that close to your property. That's my main thing. It's the ordinances are there for a reason, the setbacks. I don't think we should avoid them. I mean, if that's the case, I mean, why do we have them to begin with? So, but that's all I got to say. I'm asked them not to do it when they originally was doing it, and they just went ahead and put it up. So,
Any questions for the person? Okay.
If this were modified to be more so like a carport in better shape than it was originally, what's your thought on that? Is that something that would help with your property value?
well, if it looked decent, yeah. I mean, but even the carport was just, they never kept roofing on it, and most of the time when it was a carport, it drained it right on top of my fence. That's why I never thought anybody really had any problems with just a carport, something that's temporary, but, a permanent structure like this is going to make a big deal on property value.
Thank you.
Mr. Richardson.
So just to be clear, you live at 608
608, yes, ma'am.
North Mount Carmel. And you have a garage in your backyard as well.
Yes.
The aerial looks like it's closer than,
It is,
to the fence.
yeah, when we put that up, it was, the setback was, I think, 4 foot. It's 4 foot from that fence there, from my property line.
when was it built?
In 1987, 6 or 7.
I guess I'd ask the staff, the setbacks have not changed, have they?
No, but if it's in the back half of the lot, then it can be within 3 feet.
Within 3 feet, okay, on the back half. And it's detached and it is in the back half of the lot, so, okay.
Any other questions? Thank you. Anyone else from the audience wish to comment on this? I'll bring it back to the commission.
We need rebuttal.
We can, sir, would you like, the applicant like to come back and say anything about what was said? You have, no? Okay, nothing. Mr. Warren?
I asked a staff question.
Yes, sir.
Since this was done without a permit, has anybody looked at the building in terms of building code? Has it structurally been looked at by anybody to determine whether or not it meets building codes?
As far as I know, that has not occurred. That's why I had that stipulation that if it was approved, then they would need to go through that process to make sure that it was up to code. To my knowledge, it has not been so far.
Well, we're putting the horse before the cart.
I've got a couple of questions
Mr.
too.
Daly?
On the side of the residence that it's connected with, what about the drainage there? There's a roof that points right towards it. Where's that water go?
You mean right here?
Yeah.
Is that what you're referring to?
I think that,
Yeah,
if that's the residence that this is connected with.
Yeah, I don't have an answer for you on that one. My comment was specifically to try to mitigate any hardship that there might be on the neighbor. As far as what was present on this property, I would assume that if they were to bring it up to code, then that would address that issue if that issue was present at this time.
And on the other side towards the neighbor, it was stated it didn't have siding, so it may not be a problem, but if it did have siding or if ever siding was added to it, how would you maintain it with that close of quarters between the fence and the side? So that's just what I think. You don't have an answer for that, but
Right.
that's something to consider.
Any other questions? Mr. Foster?
I have a question. I recall, and you mentioned that this body has looked at these and similar ones, but I'm trying to recall, there may have been one that was an actual enclosed structure. I think the others were carports, is what we've looked at, and I'm having trouble remembering even one that was enclosed that was similar to this. That's what makes this one unique.
Those similar ones I could find when I was looking back were carports for the most part. I don't recall off the top of my head. I want to say there was an enclosed structure at some point in the past couple years, but I couldn't find any cases where any of them had been denied, which is why I made the comment previously that our comments were just in keeping with that kind of precedent that's been set so far.
Thank you.
Mr. McKay?
Well, I'm looking at the two pictures, the one was taken in 15 and the one was taken in 17. Am I under the impression that there is no side walls on the side to the neighbor's house?
I couldn't really get a great look at that I don't remember when I was there taking the pictures on the site whether or not there were sidewalls. At the time when this picture that I think this is one you're referring to was taken, there don't appear to have been. I can't speak to whether or not they're there now. It sounds like there aren't any based on what I've heard from the neighbor.
There is, he's got sheeting inside on his inside, not on the outside. You don't have any siding on the outside.
So the neighbor indicates that there's sheeting on the inside, but not on the outside.
I'd like to have the opposition guy come back up if we could.
Sir, the gentleman that spoke against this, would you come forward?
Sir, have they enclosed that south side like with stud wall and stuff like that and put siding or any kind of?
I don't know how they could get siding in there. I'm telling you, there's less than a foot between that and my fence.
You made the comment earlier that they had put sheathing on the inside.
Inside, they have sheeted it up
Build a
and
stud
got,
wall to put the sheathing on it, or did they just nail it to the existing structure?
yeah, they just nailed it to the existing structure.
They didn't go in there and put a stud wall or anything in? Okay.
No.
Yeah. Any other questions? Okay, thank you. We'll bring it back to the commission, as it's been here, I guess, for a while.
I'd like to make a motion for denial.
I second that.
Okay, we have a motion by Mr. McKay for denial and a second by Mr. Daly. Any more discussion?
Just one question, made a motion. If it was in the deal, if we deny it, they have to tear the structure down. Just the garage, or can they leave the carport, or everything have to go?
The only thing in their question is a carport, right?
No, I'm talking about the carport was there prior to, looks like they just put a facade on the front of a carport, is what it looks like to me.
That'd be up to MABCD, but if they're encroaching in the side yard setback with a carport or an enclosed garage, then they'd either have to come back.
Is there a time limit that's set that they have to take it down?
MAPD is not involved in the enforcement end of it, so I don't know what all notice and legal requirements
Oh,
they
okay,
have.
thank you.
Mr. Green?
It looks like the existing garage that's back there in the back was grandfathered in. So I would assume there would just be the carport that would be
That's what I was thinking.
necessary
Is that correct? Or-
at this point to be taken down. Is that right?
This variance request was for the carport that was then turned into the garage. So if a denial would be for the structure that you see here, the carport, plus that facade that was put on the front of it. The previous garage was existing prior to this and was not a part of this particular application.
It was grandfathered in at some other times.
Thing. Any more discussion? Seeing none, all in favor of the motion?
Aye.
Opposed? Okay, 2, 4, 6, 8, 10, 12, 13. 13 to 0 for denial of the variance. All right. I hereby adjourn the zoning appeals board, and we'd like to have the announcements now. The MAPC, that's what it says right there.
Before we begin the agenda, the Wichita-Sedgwick County Metropolitan Area Planning Commission would like to take this opportunity to welcome everyone to this public hearing. Copies of the agenda for today's meeting, the public hearing procedure, and Planning Department staff reports on all agenda items are available on the counter in the lobby of this conference room. The Planning Commission's bylaws limit the applicant on a zoning or subdivision application and his or her representative to a total of 10 minutes of speaking time at the start of the hearing on that item, plus up to 2 minutes at the conclusion of that hearing. All other persons wishing to speak on agenda items are limited to 3 minutes per person. However, if they feel that it is needed and justified, the Commission may extend these times by a majority vote. All speakers are requested to state his or her name and address for the record when beginning to speak. When you are finished speaking, please write your name, address, and the case number on the sheet provided in the lobby. This will enable staff to notify you if there are any additional proceedings concerning that item. Please note that all written and visual materials you present to the Commission will be retained by the Secretary as part of the official record. If you are not speaking, but you wish to be notified about future proceedings on a particular case, please sign in on that same sheet. The Planning Commission is interested in hearing the views of all persons who wish to express themselves on the agenda items. However, we ask that all speakers please be as concise as possible and avoid long repetitions of facts or opinions which have already been stated. For your information, the Wichita City Council has adopted a policy for all city zoning items. A copy of this policy is available in the lobby. The City Council relies on a written record of the Planning Commission hearings and does not conduct their own additional public hearings on these items.
I'd like to call the meeting to order. Let's look at our subdivision committee recommendations and see if we have any of these that can be taken by consent. The first one is 2017-00039, a final plat for the Warmer Plaza Second Edition. Anybody want to hear that on the commission? Okay. Just a question? Okay, anybody in the audience would like to hear that discussion? Okay. Okay, subdivision case 2017-00047, one-step final plat, Buck Edition. Anybody in the commission like to hear that one? Anybody in the audience would like to comment? Okay, do we have a motion on 2-2?
Moved.
Second.
Okay, did you get that? Mr. Johnson made the motion, Mr. Klossmeyer seconded. Okay, any discussion? Seeing none, all in favor?
Aye.
Opposed? Okay. Oh, yeah. All right, let's have a staff presentation. Maybe we don't need a presentation, and we'll see what the question is for Mr. Blick. We'd like to go ahead and ask your question.
The question I have is the,
Pull your mic over to you.
sorry about that. Sorry about that. The plat to the south, I was just wondering what's its zoned, because I didn't see it in the packet.
The property to the south?
Yes. Is it zoned exactly same as what the property to the north is?
The property to the south is SF5.
Okay. That's the only question I had, because I didn't see it and I couldn't find it, so.
Any other questions? Mr. Foster?
Neil, just real quick, when I went through the staff report there, I was trying to sort out what that street name, we talked about maybe making it a court, but is it gonna be a circle now?
GIS did look at that.
Uh,
As I recall, I think this is believed going to be a circle. This stays at 36 North, and this now is going to be called Circles, if I recall correctly.
Okay, just want to make sure. Thank you.
Any more questions? Do we have a motion?
All moved to approve.
Mr. Green made a motion.
Second.
Seconded by Mr. Richardson. Any discussion? Seeing none, all in favor? Aye. Opposed? Okay, 13-0. I overlooked the MAPC meeting minutes of October 19th, 2017. Do we have a motion?
Move approval.
Second.
Mr. McKay made the motion, Mr. Green seconded. Any discussion? Seeing,
I just have a comment that on page 10, there is my name, but it didn't have what I said. But by looking at the rest of it, and I know I asked that is there a separate instance at the back, and it was affirmed that there was by both the planner and the applicant. So just as a note that I did say something.
okay. Like to have the minutes reflect that?
Well, I've talked to Anna, and she said that the final minutes would reflect that.
I need to abstain.
Who else? Who else did
Josh.
not attend the 19th meeting? Mr. Foster? Ms. Miles?
Yeah, for myself.
Mr. Blick? Okay. All right. Do we have a motion?
motion. is
That's right, I'm
seconded.
sorry, we had discussion. Any more discussion? Seeing none, all in favor? Aye. Opposed? Passes 10-0-3. Okay. Let's turn to our public hearing vacation items and see if we can take any of these by consent. We have vacation case number 2017-00043, city vacation of the west 11 feet of the eastern 15-foot side yard setback for a storage structure. Anybody on the commission like to hear that case? Seeing none, anybody in the audience like to comment? Okay. Vacation item 2017-00043, city vacation of a portion of access control and use restriction concerning Reserve E in the Bradford North 3rd Edition and concerning Lot 15, Block 2 in said edition on property zone TF3. Anybody?
44.
44, sorry. Anybody wish to hear that case? Anybody in the audience wish to hear? Okay. Can we have a motion on 3-1 and 3-2?
So moved.
Second.
Mr. Richardson moved and Ms. Miles seconded. Any discussion? Seeing none, all in favor?
Aye.
Opposed? Okay, that's, both of those pass 13-0. Okay, we're going to hear case number 4. Anybody on the commission want to hear number 5, which is 00037? Mr. Warren want to hear that, so we'll hear that. Item 6 is case number 2017-00038. Anybody, Mr. Foster, like to hear that one? Item number 7 is 2017-00039. Anybody like to hear that, Mr.? Okay. Perfect record so far. Case number zoning 2017, case number 00051. Anybody like to hear that? Anybody in the audience wish to hear 00051? Seeing none, we can take that by consent. Okay, number 9 is the zoning 2017 00052. Anybody
Just
like
had
to?
a staff question on that.
And Mr. Blick wants to hear it.
Same.
Oh, say, just a question?
Just question.
All right, well, so we'll do whatever we have to do there. All right, let's go back to case
Move
number.
that we approve item number 8.
Yeah, second. Mr. Hartman, okay. Any discussion? Seeing none, all in favor?
Aye.
Opposed? 13-0. Okay, we'll go back to case number 4, 00033. And we have staff presentation, David?
Heard this before.
Right. We're gonna hear this case and we're gonna ask for public comment.
Thank you, Mr. Chairman. Dave Ear, Principal Planner. This is the request from Verizon to construct a 150-foot tall wireless communication facility on the east side of 127th Street north of 63rd Street south. The case was heard in October, went to the Board of County Commissioners and was considered by the Board of County Commissioners on November 29th. And following extensive discussion and presentations by several people, the Board of County Commissioners voted to return that matter to the Planning Commission for reconsideration. The reasoning behind that was a request for discussion concerning the east-west setbacks, primarily east of 127th Street. As outlined in the staff report, this matter comes back. There are statutory language regarding reconsiderations, and it's our opinion that effectively The item before the Planning Commission today consists of a consideration of whether or not to resubmit your original recommendation, which was to recommend approval of the tower and to grant the waiver of the compatibility setbacks concerning setbacks from 127th Street and also from the north property line. This is the location, if you'll recall, this is a little aerial that shows in the blue box, that's the location of the proposed tower, 127th Street. This is 63rd Street to the south. We'll go through the slides real quick. For location of this in respect to the comprehensive plan, we're adjacent to but do not actually touch the urban growth area around Derby. This was a site drawing prepared by the applicant that we showed last time. You can see the little L-shaped lease area that was the legal description of this case, with entrance off of 127th Street, coming in parallel to the tree line with the north property owner, and then it turns, goes back south to the compound area itself. This is kind of the drawing of in their construction drawings, and here you can see more of the blow up of what it looks like with the entry drive off 127th Street, and then the fenced compound with the tower location at here within the center of the lease area. Within the presentation, also you'll recall from when this was heard before you last time that there were concerns about screening requirements, and the applicant is proposing that the compound, if I was to back up, the compound around the tower structure, they will have a solid wood fence completely around that compound area. This is the aerial that looks along 127th Street looking north. The entryway for the compound is roughly right at this location. It would come in along the tree row and turn south. You can see the mature trees on the west side of 127th Street. This kind of looks at where the tower would be located, roughly right in this area. This is 127th Street looking south, roughly from the entryway to where you would get into the compound. You're looking west across 127th Street, and you're seeing the trees on that west side. Now, these are mostly deciduous trees. They're heavily leaved at the time that we took the picture. I think if you took it today, you probably wouldn't see as many leaves. But that's the location of all the information regarding that. Staff's recommendation to you is primarily to just return the matter to the Board of County Commissioners with no change to the recommendation. As outlined in the staff report, we also believe that you have the alternative that if you wish to reconsider your recommendation by essentially not recommending the waiver of the setbacks, it would change it to a recommendation of denial for failure to comply with the setback stipulation, the compatibility setbacks. Effectively, if you'll recall from the staff report, the side of the structure, by doing the math outlined in the code, would mean that the setbacks would need to be 395 feet from 127th Street and 395 feet from the property owner to the north. We believe those are the issues before you. Within the staff report, we gave you just a repeat of the information we had that was considered at the original hearing. But this is a return matter to you. Statutorily also is a requirement that if it says in KSA 12757 that if it comes back to the Planning Commission and there's no action taken after the first official public regular meeting time, then it automatically can go back to the governing body with a resubmission of the original recommendation. We would like to see the Planning Commission to at least vote to take an action on this today. We've had discussions with the applicant, and I think in their presentation, they will address this question. But the idea has been, presentation to the county commissioners indicated that there were negotiations with the landowner to the possibility of moving the tower further to the east. If you will recall, in the presentation a month ago, and as well as what was the discussion at the Board of County Commissioners, there was opposition to the idea of moving the tower further east, primarily from Cook Airfield. And there was a presentation made to the Board of County Commissioners. I don't think I have that information in this, but that kind of showed their plans of possibly modifying and making other improvements at Cook Airfield, that a tower further to the east, they believe, would have more impact on their future plans. You as a board have not seen those plans officially yet, but there was some discussion and kind of a presentation of what was being talked about at that time. That will be an item that we'll address in the future regarding Cook Airfield. But the idea of moving the tower further to the east was proffered by the applicant's representative, and Mr. Holland is here today. And that's kind of the basis of why this has come back. So I hope I've explained to you what really we're asking you to consider today. And with that, I will stand for any questions you may have.
Mr. Johnson.
I'm curious, if we move it to the east, does the application have to be refiled?
Well, we've had that, yes. Extensive discussion about that, because this application gave a very specific legal description of the proposed lease area. And all the notifications and everything that have been done have been off that legal description. So if there is a new location, then it will need to be a different, and we'll start the process all over. The debate is, and I think Mr. Holland is prepared to discuss that today, we've proffered the idea of saying, if you withdrew this request and started it over at a new location, we would handle that as resubmission and treat it as the same case. But I believe he will address the issue to you that they don't want to do that, so.
Any other questions? Let's go with Mr. Daly first and then Mr. Richardson.
If they were to move it back, in the future, could the bordering to 127th be sold to somebody else and then they can build a home or get it rezoned to do something else after
Well, once the
that?
tower's there, as future transactions occur in other divisions, you're dealing with an existing structure.
Okay.
If the setbacks at that point are not going to be, well, acknowledged, it would only be if there were further modifications to the tower, would that be an issue on setbacks at that point. But, we're treating the compatibility setbacks based on conditions as they exist today. And if the approval is ultimately given, even if this moved further to the east, the whole issue about impact on setbacks are for new structures, not something that's already there.
Okay, thank you.
Mr. Richardson.
Dave, I'm a little bit confused about the position as you know it with regard to Cook Airfield. We've talked about a 250 feet. In our packet, it indicates the airfield would be okay if it were no farther east than 395 feet. I understand you can't speak for them, but your understanding based on what happened at the county commission, are we saying that this could go as far east as 395 feet and still be okay with regards to the airfield or not?
Well, the 395 feet would then remove the compatibility setback issue. But what it would, as far as where a Cook Airfield might be about that, we have verbal information provided both at the original hearing here as well as what was presented at the Board of County Commissioners meeting, but I don't know that it's necessarily clear. The decision of the Board of County Commissioners, that was a motion made by Commissioner Dennis, and he has been asked repeatedly about whether or not it was more than just the east-west setback. He said, no, that was the only basis of his concern. So the setbacks from the property line to the north was not a concern in terms of what was a basis for the motion he made to return it to this board with regard to setbacks. The only real issue in terms, because what the statute envisions when the Board of County, when the governing body returns something to the Planning Commission, and I'll also defer to the county councilor on this as well to make sure we're clear, but it's essentially that it asks that if a governing body votes to return a matter to the Planning Commission for reconsideration, they're supposed to, they being the governing body, you're supposed to give you, the Planning Commissions, what are the issues? What do you want? What are they wanting you to reconsider? That issue is the east-west setback, and that's the only issue that's back. So it's effectively, you have the latitude to resubmit the original recommendation, or you can modify it, but we believe under the circumstances of this case, the only real modification is to acknowledge that we don't meet the compatibility setbacks and say no. And if it moves, it's going to have to start over as a new case.
So the position.
And we
of the-
have no clue where Cook Airfield is. And I don't know if we have a representative from Cook Airfield here today or not.
But the position of the staff is that we really can't act upon what the county commission wants us to consider, which is to change the setback. Your position is if we want to consider that, we'll have to deny this and ask them to come back with a new application.
Either to approve it as originally submitted or recommended, which is waive the setbacks and leave it at this location, or to acknowledge that unless the applicant is willing to withdraw and resubmit, that we're dealing with either a denial of the request as submitted, yes.
And if it's denied here, does it go back to the county commission?
Yes. All you're doing is, it's a recommendation, you don't make the final decision.
Questions for staff? Okay, at this time, the applicant or agent. Get it right this
Your
time.
red button.
You have 10 minutes. You don't need to use it all.
Thank you, Mr. Chairman and the Commissioner. So my name is Curtis Holland. I am the attorney for Verizon Wireless in this case, and as well as representing the landowner on the application. And
Your
so
address, sir?
I was here last time. We had a very thorough discussion about this the last time.
Could you state your address?
I'm sorry, 6201 College Boulevard, Suite 500, Overland Park, Kansas, 66211. We had an extensive discussion on this application the last time. At that time, as you know, the Planning Commission recommended approval of that application with the waivers, I think by an 8-3 vote. It did go to the Board of County Commissioners on November 29th. So Mr. Yearout did explain that the county commissioners did consider your recommendation for approval. And at that time, we did bring forth some new information to them, and I think that's why it's come back to you. I want to first indicate that it's our preference, Verizon Wireless, as the applicant in this case, that you affirm your prior recommendation for approval. There's been really no change relative to that application that would require or really cause you to make a change or a different recommendation to the Board of County Commissioners. So we're asking you to, one, affirm your prior recommendation for approval. We are in agreement with the original recommendation. I do want to bring some new information to you, though, and talk about that. And it's not necessarily for your consideration today in your decision. It's something that might be considered in the future if we bring it back to you. And that is this idea that we would potentially move the location of the facility to the east. Basically, where it is today in the position of the facility, leaving it in the same position relative to the north line, but moving it due east on a line. When we came before you the last time, the reason the position of the facility was in where it was and where it is as part of our application is because that's where our landlord wanted to have it be placed. They didn't give us any real latitude to move it. However, after after your all's meeting, the first time when we met, and hearing what the residents had indicated, the residents, if you'll recall, wanted a movement of the facility further to the east, about 1,000 feet from the road, and we said we couldn't do that. But we did talk to our landlord about possibly moving it somewhat further to the east to try to mitigate their concerns and just be a good neighbor to the extent we can. We want everybody to be happy here with our facility, even though that's probably not possible. We did have, I think, some understanding from the residents that moving it east would be good. However, if you'll recall, the Cook Airfield representative who was there at the meeting in front of this body indicated that it would be in their preference that it not be moved any further to the east from where we were currently showing it. They changed that position a little at the Board of County Commissioners meeting, and essentially indicated that they would be okay with it if we met the setback. In other words, move it 395 feet to the west and 395 feet to the north. If you stay within the setback, we're okay. If you start to move it any further to the east of that setback, it starts to cause us a problem. So what we had talked about before the Board of County Commissioners in terms of moving it, and this was a concession that our landlord made after we asked, and that was to potentially move or adjust the facility to the east 250 feet or up to 250 feet, really, east of where it is where we're proposing it. And in essence, by doing that, we would meet the setback from the west. And as I understand the Cook Airfield position, they would be okay with that. If we move it that far and no further, they would be okay with it. But beyond that, they indicated they wouldn't be in support of a movement further to the east. So we're trying to meet differing interests here as best we can. We're trying to meet the interests of the residents and their interest in moving it to the east as far as possible, and Cook Airfield's position that they wouldn't want it moved. They're allowing for some movement, but not too far of a movement to the east. So we're trying to satisfy both folks. I do want to just quickly on the PowerPoint, this is the thumbtack is where our proposed location is, and that's the subject of your application. We're asking you to reaffirm your recommendation. This is Cook Airfield, the star, and it's some 4,000 feet this direction and over a mile as the crow flies from their end of airstrip. The next slide here is the position of the tower where we are proposing. It's the subject of the application, and we had some distances, which I think you've seen this before, relative to the adjoining residences and their measurements to their houses, their structures, because I think that's where most people spend their time. And just to give you an idea of how far away that structure would be. And then I have here the second thumbtack. That's this proposed potential alternate location that is 250 feet east of the current proposed location. And I want to show you what happens if we move it there. We do increase, a couple hundred feet the distance between where the tower would be and the houses that surround it. These distances all increased by a couple hundred feet. The distance to the McPhail residence to the north is a little bit less. It was 320 and now it's 285. It's in a position off to the side of the house, which we thought would be less of an impact than having it in the front of their house or really towards the rear of their house. But this is kind of over in this area where the arrow is where I think the McPhails wanted to have the structure, and where I think the residents who live on the west side of 127th were okay with moving it out this way. This is where we got into the rub with the Cook Airfield guy, and they said, no, we don't like it out that far because of our airstrip. We have a future plan to move the airfield and expand our operations and so forth. I know it's a plan. I don't know how immediate it really is based on what I heard at the Board of County Commissioners meeting. They don't control the land where they would need to build the airstrip, so I think they'd have some work to do what they want to do. In any event, this is the proposed alternative location that we would be willing to move it to this location and have you guys consider that location. our method of process for doing it, I'll get to that in a minute, would be essentially to keep this application on the table, keep it moving forward. It has already been filed and you've already considered it and reconsidering it now. If we're fortunate enough, regardless, I guess, rather, I'd say it that way, regardless of what you do, whether you affirm your original recommendation or change your recommendation for reasons I'd like to hear, but if you change your recommendation, our position would still be to keep this application alive, move it forward to the Board of County Commissioners. However, in the interim, what we would agree to do, assuming our landlord is okay, is we would submit this application, a second application, and bring it before you and have you consider this new location where, get the arrow to work, right here, approximately right in that location, have that be brought back before you as a second application. What we would then do is take both of the locations. We'd have two different applications. Take both those applications to the Board of County Commissioners and let them decide. I think it's pretty easy which way they'd go. We'd probably put the new location on the agenda first when we get to the Board of County Commissioners. That way, if they approve it, we'd probably just withdraw this location or this application while we're at the podium, if that happens. So this is kind of it's not in front of you now. It's a plan to bring it back and have a new application put before you to have it considered here. I don't know that makes everybody happy still. I know based on Mr. McPhail's comments that he wouldn't be excited about this location either. It does meet the Cook Airfield parameters. It does move it further east of the road, and it's something that our landlord did agree to with us. And so we think we can push it to this distance. Late in the game, Mr. McPhail proposed to have this facility put on his property as a means to satisfy everybody, and I don't know what good that does to move it up there, and I'm not sure. I know we wouldn't probably pursue that, and I don't know if that's still on the table, but I think even just driving down here this morning, and I am going to have to reserve some time to visit to just talk back to you, because I know the residents have another proposal to you that I just heard about as I was driving down from Kansas City today, and that's to move this facility.
Mr. Holland?
Yes, sir.
Before you start on that, I can grant you up to 2 minutes.
I'll try to be quick. You'll hear, in fact, you're going to hear this from the residents, so I'll let them talk about it in more detail, and then I'd like to come back and speak to you about it further if I can. I think there's a proposal that I know there is, that where the residents would like to move this a little bit further to the east, not necessarily all the way out here where I think they had wanted at one point in time, and they'll have to clarify this for me, but somewhere a couple 100 feet this direction. And so I'm going to guess it's in this area for maybe moving it that direction. And we hadn't thought about doing it. Well, I guess we did. We'd asked our landlord whether we could move it, and they said yes, but no further than this 250-foot distance from this location to this location. But I guess our landlord has had some discussions with the residents, and I'm just hearing this, so I can't confirm it, but I'm understanding, and I believe them, that there's some reception on the part of our landlord to allow a movement further out this way. So where that comes into play is if that's in fact true, and if our landlord's willing to put it there, Verizon wouldn't necessarily be opposed to moving it out to that location, subject to getting FAA approval, keeping the tower height the same as it is. And I guess we'd like Cook Airfield to like it. I don't know that they will, but if Cook Airfield's on board with it, that's great, because then we have all parties probably in agreement with it. But you'll hear more about that today. And I'll close and again, just like the opportunity to come back and speak to whatever it is that the residents have to say about this. And again, our request is that you reaffirm your prior recommendation, and then if we get past today, we'll probably come back to you with a new application for a different location, either at this location here or at some other location out here that the parties agree to.
Mr. Holland, you will have time for rebuttal. Any questions for Mr.
Questions
Holland?
for me?
Hello, Chairman. Justin Wagoner, Assistant County Counselor. I did just want to advise you all that what's been referred back to you is the application area that's in front of you. While there was a lot of discussion at the Board of County Commissioner level about what I'll call the first alternative location, and I think it's probably fair game to consider that, I would suggest against getting too much determinations, either approval or non-approval based on that. And I would also suggest keeping conversations or not entertaining indications of approval on an alternative location or what may be referred to as a second alternative location that's been presented today. Ultimately, if those come in front of you, there will be either an amended application or a new application that would be filed. But really, your charge at this point is to consider what the Board of County Commissioners have submitted to you, which involves, whether you want to resubmit your prior recommendation, whether you wish to consider the setbacks from the west side property line, and then ultimately, as Dave Yearout mentioned, the third option is that if you fail to deliver a recommendation, your original recommendation submitted.
Can I ask you a question? Sure. Does the county commission have the right to move it without another application?
No, they do not. That's up to the applicant. You can't really amend an application on the fly. There's a as Dave Yearout was mentioning, there's a specific legal description that the application area is based on. That's where the notice goes. That's where how the protest is calculated. And so in order for that to occur, that would be up to the applicant.
Thank you. Okay, Mr. Johnson.
Question for legal. If we just send it back the way we approved it previously, what does the vote have to be at the county commission to approve it?
To approve it, they require 3 votes.
Even though there's a protest filed?
The protest is only valid to the initial public hearing. I believe there's an AG's opinion on that as well. And if the protest doesn't carry to... Dale's indicating that the protest would stand. I'd read an AG's opinion a couple weeks ago on that particular question that said that...
Okay, the other part of my question is, if we send it over there, does it take a 4-1 vote to deny it?
No, it would only take 3 votes to deny it. If it was the overriding of the planning commission only applies the first time the Board of County Commissioners gets it. The second time it comes in front of them, if it's a override of the planning commission, it only requires a simple majority vote.
Thank you.
Mr. Hartman, did you have a question?
I had a question for the gentleman at the podium. I was wondering why you would continue with your original submittal while you were doing a second one.
Well, because this way we would have a choice between the two. There's no guarantee that we're going to get the second one approved. I don't know what Cook Airfield's position is going to be or what the Board of County Commissioners would say with regard to Cook Airfield's objection. So in our world, it makes better sense to have a second application be submitted for the new location. It would have to come back to you. It would come to you with a notice of public hearing, and you would hear that case. This case that's before you would essentially stop. And it would wait until you guys act on this second application. And then we would take both to the Board of County Commissioners and let them decide if they prefer one or approve one. If they approve one, I mean, we're going to withdraw the other. My assumption is they're going to approve the one to the east, but I don't know that for a fact, so.
I'm not sure you control when it goes back to the county commission, do they? So
Well,
if we take action today, it's...
I'm under the understanding I do have the opportunity to request that it be tabled, and I would ask that it be tabled, that there is, although there are federal laws that require and that trigger a shot clock, that we would agree with the county that the shot clock would toll, and that we would, we would be working with the county on that. We wouldn't. So yes, I think they can. I think we have some control. I'm not sure we have total control. I'm just telling you what our intention and our hope would be.
Are you offering to do that before we act, or do you want our decision first?
I need I think you need to make a decision, either a reaffirmation or a change in your original recommendation. This case, you have to make some decision on this case.
Okay.
We're not withdrawing the case.
Okay. Mr. Richardson?
So, asking a legal question here, he could table it before it goes to the county commission, can't table it here today, is that right or not?
I think it's correct that today they cannot table the matter because the statute requires this be heard at the next planning commission after you have received the recommendation from the Board of County Commissioners, or I should say the request for rehearing from the Board of County Commissioners.
So that, in being able to table it applies to the county commission, perhaps,
correct.
but not to us. We're going to have to go ahead and make a decision here one way or the other.
You would have to either make a decision or make no decision, in which case that would be the same thing as reaffirming your decision, just not making a vote on it. But legally, it would be the same thing.
Okay.
Daly?
I've got a question for legal, that we're just to consider only what the county commission wants us to consider, this one place only.
That's correct.
So would it be inappropriate for other people to get up and offer other areas on that we can't consider anyway?
They can get up and comment on it as they wish to, but as planning commissioners, I would suggest that you consider what's been asked of you from the Board of County Commissioners, which is the east-west setback, or essentially the setback from the west property line on the application that's in front of you. And then I think the other stuff, some of it may be immaterial really to what the hearing is today.
Any other questions for the applicant? Okay, thank you. At this time, we will turn to the audience, and we will give the audience a chance to speak. It's my understanding we don't have to, but I'm making the assumption we will here. If anybody disagrees with that, you can, Mr. Warren.
Just to make sure that we're on the same page, I think that needs to come as a vote. So if someone will recommend that we have a hearing, that I don't think that we can just make that assumption. That I think it's a decision of the board. So if somebody wants to hear it, we should.
You also
should be a
can
motion.
limit their time, because that's our discretion, I believe.
We limit the time if we do.
I'm sorry, I didn't hear the question.
Let's have the motion talk about that
I'd
also
like to have some discussion beforehand.
before we make a motion. Okay?
I guess what I'm curious about, rather than hearing everything we heard before, I'd just like to hear any additional new information, not go over and over and over about what we've heard before.
Got a motion?
Okay, I wasn't here originally, so this is new information for me, so I'd like to hear it.
Okay, I guess we're gonna hear it.
Okay, anybody want to limit the time per speaker?
Let's see how many speakers there are.
We have an indication how many speakers we may have. 3, and maybe somebody else will be moved to speak beyond that. We never know.
I'd like to make a motion, because we've heard it before, that we limit it to, 5 minutes per person?
Threes are
3.
He's fine.
Yeah, each speaker has 3 minutes presently, unless they get an extension.
Okay, so you're making a motion, we hear it. Okay, do we have a second?
Second.
Okay, any discussion? So the motion is that we take public comment. And we have a second. Everybody in favor, say aye. Aye. Opposed? Passes 13-0. First speaker from the audience, please.
Before he starts, I'd like to, the reason why I made that motion is because there's been a proposal with some new ideas that they've talked with the neighbors about. And that's maybe what will come up at this meeting. That's the reason why I wanted to hear it.
We'll pass those around. Go ahead.
It just,
But we can listen to it. We can't act on it.
We need 4 of them.
You are earning your money.
Chair,
I got 2 there.
pass that.
Get one more?
It's coming.
It's coming.
It's coming, Joe.
It's coming. That's it.
This is something different here.
It's the same. The first one we passed out.
Oh, here's this, okay.
Sir, your,
Yeah, this
please
is
state your
same.
name and address.
Okay, I'll pass that on.
Yes, sir. My name is Stan McPhail. I live at 6140 South, 127th Street East. I am the property owner directly north of the proposed site that has been brought back to you today. The first thing I'd like to address real quickly is that I handed out a short sheet that says basis of return to the MAPC. There are 3 items there that when we looked over that we would like to bring to your attention that I don't think are quite accurate. And since they've been mentioned this morning or this afternoon, I'd like to just mention them to you. There's one comment that's in the second paragraph on page, and that refers back to page 2. It says the attorney made a statement concerning the negotiations between the 2 parties. I don't know who the 2 parties are because there's never been any negotiations from Verizon to us. There's never been any direct contact whatsoever from Verizon to the property owners. So that is not a correct statement to be made. The 200-foot concept originated with Verizon somewhere. None of the property owners were involved in that number. The second item is that when it said most property owners in the area who spoke had less objection to the alternate location, we're talking about 250-foot location. That I was the only property owner that was directly asked the question about the 200-foot additional movement. And that was a direct question from Commissioner Howe to me. And at that point in time, I told him absolutely not. That would not be appropriate because all that did was move it from the front of my house to the back of my house. And that there would have to be movement substantially farther east for that to be considered acceptable to me. The third thing is when we're talking about Cook Airfield is that 395 setback that they mentioned in this document that you guys had, it failed to mention that they also talked about they would like to see them, if they go 395 east, to be made to go 395 south. So they did meet the complete zoning code. So those are just a few elements in there that we have a little difficulty agreeing with, and I just wanted to bring those to your attention. I know you said you didn't want to rehash a lot of things, so I'll try to in this other document that I gave you, just kind of skim through and give you our general attitudes about this. Mine is that, skimming through here, is that the master plan was designed for a reason. It was designed to protect the property owners from intrusion from cell phone towers. And we were asking that the county commissioners and you adhere to that setback guideline. That's what it was intended for. If you folks choose to waive that setback zoning code, what you've done is you've opened the door for this to come before you over and over and over again, because every cell phone tower is going to come to you expecting a waiver because you've already granted it. And my concern with that issue is...
Sir, your time is up. I can grant you some
Can I have a
additional-
couple of minutes, please?
I can't grant you more than 2, but I will do that.
Okay, thank you. Is that as a homeowner, you expect me to meet zoning requirements. If I do buildings, if I do home remodeling, I've got to meet standards and guidelines for that. We're asking you to make Verizon adhere to those same kind of setbacks as you expect the county residents to do. So, not to rehash everything, folks, is we'd just like to ask you to take a stand for the Sedgwick County residents and not send this back to the county commissioners because it doesn't meet with the setback guidelines. There's no extraordinary condition that would require a setback to be asked in this particular situation. I think Verizon basically has found an absentee property owner. She's elderly, and they latched onto this one corner and said, this is where we want to go. And there has been no consideration, no willingness to work with us as landowners, but we may have an option for that that's going to be mentioned here in just a few minutes. Okay, thank you.
Thank you.
Question.
We have a just
Yeah.
a minute, sir.
Question.
All right, excuse me.
Okay.
If the applicant would meet the setback guidelines, would you be happy with that?
Where it's currently proposed?
No, just what you kept talking about, well, there's rules and rules and rules. All right, if there's rules about the setback, we just follow the rules. Would you be happy with that?
you're talking about the current setting right now, going 395, that would put that 395 out in the field. To the
395
south.
395 is what it is.
Yes,
Would you be
that's-
happy with that?
Would I be happy with it? I would not have a problem with it as far as me, but I know it would be sitting right out in front of our neighbors' homes. So I think there's an alternate choice to look at.
Any other questions?
Mr. Johnson.
Yeah, I'm curious,
Yes, sir.
the location that we approved and sent to the county commissioner, then also if we would move it to the east 200, 250 feet, which position would you more likely approve over the two?
250 or where it's currently at?
Yeah.
I would have to say where it's currently at.
Okay, thank you.
Any other questions? Okay. The next speaker, please come forward and state your name and address.
My name is Larry Van Dyke, and I live at 6215 South 127th Street East, and that's directly across the road from the proposed location of the tower. We have been in discussions with Mrs. Rippey and her nephew, and I sent her a analysis of the proposed site and some comments on what the impact might be to her property. She and her nephew reviewed that analysis and got back with me this morning, and what their recommendation is to accept what we have on the last page of this, where we identified a location that is approximately 700 to 800 feet from the property owner's west property line, further east, and we would continue to accept the north-south setback as originally proposed. We've also talked to the representatives from Cook Airfield, and even though in the county commission meeting, they stated that they would be okay with the 395 setback from the west, they have since said that they would accept up to 800 feet from the west property line. We don't have that in writing, but I can get that in writing if that is necessary. So our proposal, based on the comments on the front page, this was from Marcus Fries, who is Mrs. Rippey's nephew. He said, last evening I visited with Aunt Jane about the attachment, which you have. We reviewed the documents and also the mailing which she had just received yesterday from the Planning Commission. Aunt Jean and the Rippey Trust are okay with the location marked with the octagon shape. The location marked with the octagon shape is preferred over the other locations marked with the stars, since it is acceptable to all the neighbors and the airport and would be in the best interest of the trust for future years, and I concur. Marcus Fries. Any questions?
Question.
Mr. Richardson, please.
Tell us the approximate dimensions of the octagon from north and west, please.
From the north, we're suggesting it'd be 150 feet because that's what the original previous setback would be from before it was changed last year. Currently on the proposal, it's 145 feet. We would like for it just to move to the 150 feet north-south.
I'm going to cut off discussion here. This has no relevance to our present case before us, and I would suggest if you would like to have a meeting with the property owners, the Verizon, and the airport, that you do that and let Verizon act on whatever you come up with.
We would be more than happy to do so, and we've been willing to do that from the beginning.
That's my recommendation, but it's not the commission's recommendation. But I will not accept discussion about an alternate location during this hearing. Okay? You have anything else you'd like to comment on?
No, sir.
Thank you. I did. Oh, yes, Ms. Stevens.
I would like to propose that we suspend further comments and approve our original decision be sent back to the commission, let the commission do what they wish with it, and then the parties at hand can have further discussion about alternate locations and so on and so forth.
I would like
Second.
Well, I would like to go ahead, and since we said we're going to hear it, I'd like to let the next speaker go ahead and speak if they have anything relevant to the present application. Mr.
That's
Warren.
a point of order. I think we've got the hearing that is open, plus I don't think we can take action until we give rebuttal time.
Right.
So I don't think we can stop midstream here.
And Chairman, just to clarify, I stand corrected on that item. I reread the AG's opinion. I think it deals with a slightly different hypothetical. It would require the 4 votes to overcome the protests. So I apologize for that and just wanted to clarify it before anyone else speaks.
Okay, next speaker, please come forward. If you have anything else to add and state your name and address, please.
Yes, I'm Danielle Wildeman, living at 6121 South 127th Street East. So the property I live is just west of the proposed site. The bottom line is I'm not gonna jump on everything that we have all these different proposed sites because we've been working very hard to try to get everybody happy in the neighborhood and with the landowner on board. But the question at hand, I really believe, is approving the waiver or not. So the setback doesn't meet the county requirements in the wireless communication plan. That was the bottom line from the very beginning, why we protested the site. And we just really would like to get back to the basics of letting that be denied, and then Verizon could come back and reapply for a different site on the property. That's really all I wanted to say.
Thank you. Any questions? Appreciate it. Thank you. Anyone else from the audience like to speak? Seeing none, we'll bring it back to the commission. I'm sorry. We'll bring it back to the commission to ask for rebuttal.
I'm sorry.
Just want to speak to there were some things said, I think that you're correct, that probably aren't appropriate to be considered, but I would tell you that Verizon's more than ready and willing to visit with the residents, either through their representatives. I've had multiple conversations with the representatives. I know that Verizon's contact has had discussions with Mr. McPhail directly, but we're willing to continue to talk to them about that and see how that can go after we get out of this meeting today. Relative to this meeting today, again, we're asking you to reaffirm your original recommendation. We don't think anything's necessarily changed per se about that. With respect to the waiver, and I would say this, and just want to point this out to you, that the waiver is a mechanism that's permitted for you to consider. It's not like we're violating the code by having it put here. We would be in compliance with the code, assuming you agree with the waiver. It's a part of your code, a part of the process, and allows for you to consider this. The reason we're asking for the waiver, and what I mentioned to the Board of County Commissioners, is the rule was changed last year. The setback rule was the height of the tower to the nearest property line, or to the property line. So the setback rule in December of 2016, not just a year ago, would have been 150 feet. And in fact, many structures in your community are 100 or whatever, the height of the tower or the height of the structure to the adjoining property line. That was the setback rule. You guys changed the rule last year, and now you've made it almost impossible to meet. And I'm going to guess that probably every application that comes before you is going to be asking for some sort of a waiver. And the reason is because now this little bitty tower, which is 140 feet, requires a waiver, or a setback rather, of some 400 feet. And you can't find property where you can meet a setback 400 by 400 that landowners want to, allow on their property, because it puts it in the middle of their property. So I think you're going to see almost every application have a waiver request. And it may be that we only have a waiver from one side or the other, or sort of in between, kind of as we got here, but we're trying to fit it. I mean, we would otherwise meet the setback almost. We're 5 feet off, I think, from the north, but we could meet that. We would meet last year's setback rules. So we need the waiver, and I think everybody's going to need a waiver under your new harsher setback rules. That I'd stand for any questions if you have any.
Questions? Okay. I think at this time I can bring it back to the commission.
I got a question. Question for the
for-
staff.
for
Was
staff.
the waiver was changed by whom? I mean, the setback rules were changed.
The compatibility setbacks have been there since the 90s. Prior to the wireless carriers going to the state legislature and asking for them to supersede local jurisdiction authority and get rid of the things that we can no longer ask for, one of the things that came out of that was local jurisdictions are supposed to treat wireless facilities the same as any other structure. And all the structures that we have to comply with the compatibility setback standards. And so that was basically, they got what they asked for.
So that's how we got to 395, because it's a function of the height of the tower,
Yes.
and setbacks work off of that as a formula from that. So we ended up with more setback rather than less.
Yes, it used to be 1-to-1, and then now that we have to treat them the same as all other buildings, we have to use that formula. Now, the one clarification I would make is the compatibility setbacks are made to be amended or adjusted. They're not like the setbacks that are established with an individual zoning district. The code specifically allows for waivers and modifications to fit individual sites and circumstances. And so there is a procedure that's in place, and they're using that procedure in this particular case.
But we didn't change the setback. It came down from the legislature,
correct.
says treat it like a building, and that's how we get to 395. Thank you.
Mr. Johnson.
Mr. Chairman, if I might interject on that point, that is those additional setbacks only apply when you're adjacent to residential zoning. If you're in the middle of an industrial area, it's not going to come into play. So it's not universal across the board.
Thank you.
Johnson.
I'm ready to make a motion unless there's additional discussion.
You can always do it whichever way you'd like to do.
I'll go ahead and I want to move to approve like we did before and send it back to county commissioners. The homeowner to the north indicated he liked it here better than even the proposed 250 foot to the east. So I move to approve it, send it back, confirm our last.
Second.
Okay, now do we have discussion? Mr. Foster.
Well, I want to understand, so anybody who brings one of these to us, they're going to have a minimum of roughly 16 acres just for one of these sites,
If it's residential.
if it's adjacent to residential zoning.
Well, single-family and two-family zoning, yes.
Yeah.
Yeah.
Does that not
It
seem
depends on the
excessive?
height. I mean, it depends on the height of the facility, but, in this case, they needed 395 feet in all directions. I don't think that's 16 acres.
Now, if you go 400, and then you multiply that out, it's about 16.
I mean, an acre is 208 feet square.
Right.
So.
I know. That's how I'm figuring it.
But you're talking about an area 800 by 800. If it's 400 deep both directions,
Yeah.
that's 14.7 acres.
But anyway, I think it's something that the commission ought to discuss, because that does seem a bit excessive, especially in an urbanizing area like this, and this is going to come back at us, so.
Have a question, Mr. McKay?
I'll make a substitute motion.
Any other discussion on the motion? Seeing none, Mr.
I can
McKay.
make a substitute motion that we deny the applicant's proposal based upon the contrary to the stuff we've heard today, that he's been talking with it, they're willing to change the application and to deal with the people. So that's my motion.
Legal, is it? That isn't what the commission asked for?
Well, okay, I'll just go back to the language in the statute here. What it says that you can do is resubmit your original recommendation, which is the original motion, or submit a new and amended recommendation. I think what Commissioner McKay has submitted as a new or amended recommendation, what you were asked to reconsider really was because of the setback lines. Well, I guess to your question, Commissioner Daly, I'm not sure if the motion made any mention of the setback from the west property line, which I think is what the Board of County Commissioners had sent back for reconsideration. So if you're going to clean it up, perhaps that's the area it could be cleaned up.
You're saying my motion should be the setback requirements or the
that's the
waiving
question
of the
that was
setback?
asked.
That's my motion. I thought the applicant was for the waiver of the setback requirements.
Yeah, it was
What
with
this in
regard
mind
to the,
is because of that we deny that request for of the setbacks, primarily because of what's been said here with both the applicant and the people. They've already worked on other locations. And so my motion is to deny the fact that those setbacks.
I have a second?
Second it.
and Chairman, I guess I may chime in a little bit because I'm not sure if this is, Commissioner Daly, were you asking if that was a valid reason to deny it? Was that the question? I just want to make sure I'm answering the right question. I mean, because I think I went more to the statutory language. I would say that you should vote on the application that's in front of you. You've been asked to consider the setback from the west property line. I do think as a legal matter, if that's the question on this, is that you view the application that's in front of you, and it shouldn't be that you think there's a better location on the property. And I think what I'm hearing from Commissioner McKay is that the motion was that you think that the location from the west setback is not appropriate. And
I think that's what
okay.
you said, right? And does the second agree with that's what he said?
Yes.
I just used the other part as a reason because of what we've heard, but I shouldn't say that probably.
Okay.
I guess to make sure the record's clean, if the motion maker and the second.
And they did.
Okay, thank you.
And I got acknowledgement from Mr. Hartman. Okay, so now we've come to the point where we can have discussion on the substitute motion.
Would you clearly state the motion, the substitute motion?
And I guess the other point I would add to that is that it might be useful to make findings to just substantiate the motion that's been made. Because at this point, there are no staff findings that you can rely upon for that. And in order to have a motion that the Board of County Commissioners can consider and consider to recommend or deny, it'd be appropriate to have findings along with those.
And so to address Ms. Miller-Stevens, if I understand the motion, what you're suggesting is you're not denying the request for the wireless facility, you're just denying the reduction in the compatibility setbacks.
Yes, that's what my motion I thought was.
We're just denying the waiver for the setback. Okay.
Wait a minute, what are we talking? The substitute motion?
My substitute motion, when I heard this come in, we either say we approve what we sent to you or we turn down what we sent to you, which was with a waiver of the setback lines. Not the actual application of the tower, just the waiver of the setback lines.
That's your motion.
That was my motion, yes.
And at second, Mr. Hartman, you agreed with that.
Right.
Any other discussion on the substitute motion? Seeing none, all in favor of the substitute motion, say aye.
Aye.
Opposed?
Aye.
If I need a show of hands, all in favor of the motion? All opposed? Fails 7-6. Okay, now we'll go back to the original motion, which was to move it forward as approved the last session. Any more discussion on that motion? Seeing none, all in favor?
Aye.
Opposed? Okay, all in favor, raise your hand. All opposed? 8-5, is that right? Passes 8-5. Next item. Okay, who had questions on item number 5?
But,
That's it. That's it.
Mr. Warren, you have questions? Let me clarify, was there anybody in the audience that wanted to hear number 5? I don't think so. Yes. Well, you want to hear it? Okay, Dave, would you go ahead and present
Okay, thank you, Mr. Chairman.
case number 00037?
This is a request from the landowner, Ashley Giles. The agent, Jesse Watson, is a member of the family. They own 11 and a half acres on the west side of K-15 and the railroad track, immediately north of where 95th Street would go through if it was straight through. They're requesting a conditional use permit in order to construct, which under our code is defined as a borrow pit. Their proposal is to remove about an acre of ground. This is the site plan showing the area they will ask to have excavated. The end result will be a pond on this property for their own personal use. Because they have a contractor that they will be using and removing the dirt to another location, by definition, it's treated in the same manner as any other mining or quarrying activity or any other mineral removal act occur. The plan itself, this is the aerial of the property. You can see access is off of the 95th Street exit off of K-15. It is a paved access road that comes on the west side, between the K-15 and the railroad tracks down to a crossing across the railroad tracks into the site. The applicants own and live here on this property at this location, and roughly the acre is in the southeast corner of the property where this pond will occur. You can see further west, this is the Arkansas River on the west side of the property. This issue, here's pictures of the property, here's the entry off of their driveway. We're looking essentially right across the railroad tracks. The railroad tracks are at the bottom of the property. This is the entry into the property, and you can see the homes that sit kind of to the western portion of the property. Off to the left here, that's the area roughly where the pond is proposed to be located. This is looking from their property back to the east. You can see the crossing as it comes up across the railroad tracks. And here is the frontage road. We're looking kind of north. It's that previous picture was looking here, looking to the east, across the railroad tracks, and then this comes south to this is K-15 highway on the right-hand side of the picture. There is the entrance of 95th Street on the east side of K-96 as it exists today. I'm sorry, with K-15 right here in the forefront of the picture. And that's looking the other direction. This is 95th and K-15. I'm looking west, and that should say west, sorry. But that's west to the entrance that turns into the little frontage road that goes down to the property. So that's how the property looks. As outlined in the staff report, we talk about the standards and requirements that are attached normally to mining and quarrying activity. They're requesting, because of the circumstances that this is effectively a private ownership, a small project, not intended to be a long-term, continually operating mining facility or a quarrying activity that would result in material to be continually removed, to not be subject to all those standards. They will meet as the full spirit and intent as possible of what's outlined within the regulations for those operations, which you're more accustomed to with seeing with sand pads and other facilities of that nature that are more commercial in nature. This is a small project that will be to remove the dirt. I think the applicant and their agents are here to talk about what the extent of that is. Staff is okay under the circumstances, just simply to acknowledge that they should comply with the spirit and intent of the regulations, that it is small and of short duration. Our recommendation really is tied to providing only a one-year time in which to complete this project, depending upon the scale of activity with the construction within the city of Derby, according to the agent that is going to actually be doing the work to remove the material. It may not even last that long. The closing use will be just a pond for the owners on this property. This was submitted to the city of Derby, and whether or not they wish to have any comments, and the comments came back that no, the planning commission from the city of Derby did not indicate a desire to necessarily have to be make formal comments to the board on this request. So with that, I will stand for any questions that you may have.
Warren, you had a question for the applicant, for the staff.
Yeah, a couple things, and one of them was answered because the question I had, one was, you know, what was the city of Derby's take on this, and you've answered that. I appreciate that. I hate to make a big deal out of what is essentially a pretty small project. And the other thing that makes me feel a little bit better just was looking at the aerial map that you have on the screen right now, that 95th Street takes a slight turn to the south. My concern, and also in the report that there's a number of agencies that need to approve on this, is the aspect of a future plan for 95th Street to become not necessarily a bypass, because I think the bypass option is really not viable, but certainly a major corridor for taking traffic from east to west and so back and forth there. 95th has been heavily prominent in that, and my concern is a pond located close to the property line might make that kind of a decision down the line very difficult. Can you talk to me about that?
We talked with Sedgwick County Public Works specifically about whether or not 95th Street might be further improved, and particularly as it would move possibly west, even across the river. And the comments that we received from Public Works is that, yeah, in the long range plan, it is identified in the south area as a potential for an expansion and improvement of 95th Street from K-15 going further west, probably tying in to 81 Highway. But it is not even within the transportation tip, so we're not locking anything within the next 20-year period. And there is obviously no funds it would be a major bridge. You would, in fact, according to the Public Works folks, it would have to effectively be probably start further back to the west, because they would not only have to bridge over the railroad tracks, but they'd bridge over the river. Is what they told me that would happen if they ever got that far. So we're a long ways into the future, and there would probably be other borrow pits in an area if they ever went to the point that they actually started to do that stuff.
This, assuming this gets approved, and we're looking at approximately a 1 acre pond.
Yes.
Okay. What is in place to make sure that wasn't expanded out to a much larger pond in the future?
Well, if this approval goes, it would be restricted to the 1 acre they show.
For the drawing?
Yeah,
Okay.
and I would also add, because a concern we had in the very beginning was whether or not KDOT was going to be happy with additional truck traffic entering at this location, and also the crossing across the railroad tracks, where the railroad company had concerns. The applicant has indicated that they have written documentation from both that those are okay. All of the other agencies, because of the proximity to the river, we're concerned about whether or not we would have floodplain impacts or other issues. And according to the county officials responsible for that, they said they've already evaluated, and no, this area actually kind of sits high. Now, the question you obviously have is, well, you're kind of building a pond on the top of a hill, so what kind of water are you going to get while you ride up on rainwater and all? And I'm familiar with other places around the county where that kind of stuff has occurred, and concerns about the sandy soil and whether it'll even hold water. But they've indicated they're not even going to be going down to groundwater at this location. So
That's my question. Thank you.
Somebody else's hand, Mr.
Dave, you mentioned a 1-year period. I don't see that in your recommendations. Is that something we ought to add to that?
I thought that it indicated in our recommendation that the restriction would be that it would be only good until the end of December of 2018.
Oh, I see.
If
I'm
I
sorry.
missed that,
No,
then
you're right.
I apologize
Yeah,
for that.
Okay, thank you.
Foster.
Yeah, number one indicates the excavation to be completed by the end of December 2018.
Dave, I want to make sure under the final recommendation here in the staff report, it states that supplemental use restrictions applicable to mining and quarrying, subject to following conditions, would waive those supplementary use regulations. I thought the idea was that they would meet the intent of that.
Well, that, we may need to wordsmith that.
I would
Yeah, the
recommend
intent
that.
was to waive the full listing, but the applicant had indicated willingness to meet the spirit and intent, but not necessarily by having those as hard conditions. Because the hard conditions talk about some additional fencing and security and grass and other erosion controls. And some of that was just felt like to be overkill for no larger project this was, particularly since it was not commercial.
If you'd look at that, please, I'd appreciate it. Thank you.
Any other questions for the presenter?
Joe, David, you indicate to answer his question that it's not within our purview to waive those mining requirements. Only the county commission can do that.
Correct.
right?
Yeah, but, and the request to waive that would all make a guarantee this will need to go to the Board of County Commissioners for final action.
Daley.
You mentioned that the dirt taken out of this would be used someplace else. If they left the dirt on their own land, would they have to go through with this?
We had that discussion, and if you just move it to another location on your own land, no, we wouldn't be here. But then, if then somebody starts coming in to pick that dirt up and hauling it off, we're right back in the same boat.
Any other questions for the presenter? Okay, applicant or agent? Please state your name and address.
My name's Jesse Watson, address 9529 South K15.
Thank you.
Basically, what we're wanting to do is just build a pond. I mean, we didn't need the permit if we just wanted to stockpile the dirt, but they had a project where they could use it, so we figured that we'd be able to dig it and move it off there, not stockpile it, not make it an eyesore for anybody else. Or I've got a lot of floodplain towards the back. I don't know if I'm able to show you, but everything behind the house is floodplain, so I can't stockpile it there. So it'd be stockpiled up towards the tree row by the railroad tracks or stockpiled across the driveway. And I don't think either of those are a good idea, so I think the best way is just to have Apex take it off the property.
Okay, anything else?
All I have
Any
to add.
questions for the applicant? Being none?
I've also got it set to where the local Boy Scouts, they're going to be out there camping and stuff. So, I mean, it's going to be a fish pond as well, little canoe, maybe a fountain, stuff like that. Kind of raise the property value in our opinion.
Okay, thank you. Okay, anybody from the audience like to speak on this?
My name is John Morris. I live at 9339 South K15 Highway. We're the property north of Mrs. Giles. We have some concerns. We're on well water there, and the actual soil in that area won't take a pond. It'll just drain. We have a fear that we're going to be left with an eyesore as we come in through. We share an easement. We'll be left with an eyesore that it's going to be a sand pit, not a pond. We're not on rural water, we're on well water. Okay? What happens if they dig too deep and they contaminate my well water? What am I going to do then? I can't get rural water there because of the railway line. Okay? Next thing is the traffic coming in and out on our easement. I should imagine there's going to be some heavy vehicles coming through there. Okay? Who's going to repair our easement? I paid a lot of money for last year. There's no plan at all whatsoever for that. So we plan to oppose this. I know Chris wants to speak as well, but I'll fill out my application and protest this. Thank you.
Thank you. Any questions for the speaker? Seeing none, next speaker. You'll have a rebuttal.
I'm Chris Lovelace, and my address is 9715 South 63rd East in Derby. I own the property straight to the south, the farm ground there. My big concern is where he's going to discharge the water off that pond and where it's going to go. If it goes onto my cropland, it could be detrimental, but that's the one concern. And then also with John about the ground contamination, if there's people south, which isn't on the map, but there's people south of me that could be affected if any contamination. And also, I haven't seen any plan, or I was wondering if they had done a study on the load of water coming off that highway, if it would affect the pond or not, and because it comes off. I know it comes off the highway and goes east, but then it'll go underneath the highway and go west. They tunnel it under, and some of it comes to mine, and then whatever comes onto his, that would be an extra load of a lot of water that it would have to meet. So that would be a concern I have as far as that, and then could continue and flood over onto my property too. So those are my only two concerns I have. Thank you.
Any questions for the speaker? Seeing none, thank you. Next speaker. Anyone else like to speak on this issue? Second. Seeing no other speakers, we will go back for rebuttal from the presenter, from the agent or owner.
As far as the water, it's currently going across there anyways. It goes across there, comes across the highway adjacent to my driveway, and then runs back past the windmill where you can see, and enters in the creek.
Use
Never
the
goes
mouse.
on Mr. Lovelace's property.
Sir,
What?
There's a mouse up there. Can you use that? Careful.
Oh, sorry. So the water comes in right here off the highway and runs across here, and either goes across my driveway right there, or the stuff that comes up here runs down this and goes in back here. The water will come out the back of the pond right here and continue the route it originally taken off the highway and go back into the creek. As far as the soil content, we've had the soil check through Apex. They've already said that it has the molding to hold the pond to make sure the pond's going to have a bottom. As far as the well, the creek bottom is roughly 25 foot above where the pond's. Well, let me get back to it. I have to go the other way. Roughly, the creek bottom is 25 foot above the field, and we're only going down 15 feet, so we're still going to be 10 foot above the creek. I'm guessing 30, 40 foot above the well water bed. And like I stated earlier, I'm going to stockpile the dirt if I can't get the permit to take it off the property. So, I mean, we're not really here on whether or not we can dig the pond. I'm going to dig the pond anyways. It's just whether I can expose the dirt or whether I have to stockpile the dirt. So it's not gonna make a huge difference on whatever. And as far as the easement, we're gonna be going, maybe 15 foot across his easement. His easement turns here and goes north. We'll be entering right here off my land and be going 12 foot. Maybe I'd say 12 to 25 foot up to the railroad tracks, so it won't be encroaching his easement. I've got a blade. I'd be willing to scrape it and can make sure it's like that. Last year, the Sedgwick County took over 550 loads of brush and stuff out of the creek, and that didn't seem to damage the easement, so I wouldn't think this would. I've had previous legal deals with everybody that's here speaking today, and I think that is where a lot of this come from, is the whole objection of the pond. I don't really think it has anything to do with the pond. I think it has to do with prior altercations with these people. So, like I said, I just would like to get the dirt off the property. Otherwise, I'm going to stockpile in it, and he might find it as an eyesore then. I mean, he's going to find an issue with it either way. But, I mean, if I can't get the right to remove it, I'm just going to stockpile it on the land, and that'll just further more court problems and all that. So, any other questions or anything of the dirt content, you can speak with Apex. He came here today to say whether it will hold a pond or will not hold a pond.
Any questions for the owner? Seeing,
He dug and sampled the soil, dug down to 15 foot.
can't,
Whoa,
sir,
whoa, whoa.
sir,
I didn't think I needed to give anybody else as far as, since I didn't have to have a permit to dig the pond, I just needed to remove the dirt. I didn't think I had to provide everybody with
sir,
ease.
yeah. Just direct your attention to any questions from the commission.
All right, that'll work.
Thank you.
If I solved world hunger, he'd still have a problem with it.
Any other questions? Seeing none, we'll bring it back to the commission for action. Thank you, sir.
Thank you, guys.
Move to approve.
Okay, I got a question.
Got a motion by Ms. Miles to approve, seconded by Mr. Klausmeyer. Now we'll have any discussion.
A question for you, Dave. In the staff report, we talk about requiring permits to excavate with regards to flood control and those kinds of things. Does that hold true?
Put that language in there primarily to assure that if it was subsequently determined additional permits would be needed by any state or federal agencies or other county entities that have at this point said nothing is required, that those would be obtained. But right now, the pond is not large enough to warrant a permit under the state requirements for constructing ponds. This is not impacting the floodplain. The county has indicated this will not require permits under a floodplain improvement project requirement at all. So that's language we put in there primarily just to cover our base to make sure.
Questions? Seeing none, we have a motion. Did you have a question, Mr. Green?
On your motion, does that include the language about the waiver by the Board of County Commissioners? I know it's, well, the recommended action said that it approved, provided the Board of County Commissioners waive the supplementary use restrictions applicable to mining and quarrying.
Yeah, I'm fine with that.
Okay, I just wanted to clarify that was.
We have a motion and a second.
I would suggest making sure the second clarifies that's understanding.
Yes. Who is the second? Mr. Klausmeyer, you, okay? Still having discussion here, Mr. Foster?
But if we're not allowed to recommend waiver of the supplemental use regulation, shouldn't that be stricken from the recommendation?
I think that the planning commission cannot waive the you yourselves can't waive it, but you can recommend waiver. I think
The
that's.
commission. And that's what the motion said. Okay? Any other discussion? Seeing none, all in favor?
Aye.
Opposed? 12-1. Okay, item number 6, which is 00038, city conditional use to allow an ancillary accessory apartment in SF5, 5 single-family residential zone district.
Mr. Chairman, thank you. Dave Ear with staff. This
Okay,
is a,
let me clarify here. Someone had a question from the commission, or did someone in the audience want to speak on this one? What? I think Foster had a question.
I didn't have a question. I wanted to hear the case. I did not, the staff report mentioned.
Okay, we're going to hear
this-
the case.
Yeah.
Dave?
Thank you.
Okay. This request is to obtain a conditional use permit to permit an accessory apartment on this particular property. It's probably best to go to the information that I'm providing, particularly the pictures. The location is on Majestic, this is 159th Street or the county line. We're just north of Central. You get to it by going on Sharon Street that then morphs into Majestic, where you have a lot of townhome and other types of development occurring. And these three lots at the very west end are under current ownership, or single ownership, so it's effectively one zoning lot. Location within respect to the overall comprehensive plan. This is identified as a residential area. This is actually, let me go to the last picture because it gives you an indication of what we're dealing with. This is looking west at the actual property. This is a new home under construction. This is the home that we're talking about, and this is the accessory apartment. It's a detached structure that is identified originally as a pool house. As it got moving forward with the codes department with respect to the improvements, you'll notice here that there is no quote-unquote front door on this building. The access is through a walk door in the back. And if I go back to the original picture, that's the north side of that pool house. You can see the garage and some other doors on what effectively is the north side of that building. This is Majestic over here on the far end, and you can kind of see the roof line in the background of the house on which this is attached. Because of building code requirements in order to be able to get a final certificate of occupancy, the only alternative was to make this an accessory apartment to the home. It's sitting on 3 lots. If this had been, as I understand it in talking with code officials, if this had been, and the agent, that this had been with a door on the front side or the east side that faced out here onto Majestic, it could have been considered as a second home on one of the lots by himself. But because of the circumstances, in order to make this to a point where they can finish the construction and get a CO, it needs to be classified as an accessory apartment. So that's what's going on with this particular case. These other pictures that I showed you, you can see this is on the left-hand side. That's the accessory apartment. There's the dumpster that was in that picture. This is looking north, kind of along the tail end of Majestic, and you can see the kind of homes that are sitting east across the road from that property.
Dave, do you have a question?
That's the thumbnail sketch of what's going on here. I'll be happy to answer any questions. I know that we have an agent here to address this on behalf of the applicant.
You have a question for?
Yeah, just one final question. Thanks for clarifying the application. Are there any relationships of square footage on the principal structure relative to the accessory dwelling?
Is there what? I'm sorry, David, what?
Are there any requirements related to the square footage of the principal structure relative to the accessory apartment?
That I'm aware of. I don't know that we have any restrictions in our code that limit size or anything of that nature at all.
Thank you.
Since we have no one from the audience objecting to this, is it okay if we just go ahead and ask for a motion? Anybody from the audience like to speak about this item?
Need
Oh.
Need the agent first.
I'm sorry.
Need
Is the agent here?
Yeah.
I didn't see a hand go up a while ago. Sorry.
See if we can generate some more questions. Hi, Russ Avey, Boffman Company agent for the applicant.
You're just going to stand for questions, right? Any questions for the agent?
I didn't pull this off, yeah.
Okay, seeing none,
Thank you.
thank you. We'll bring, anybody in the audience like to speak on this item? Seeing none, bring it back to the commission.
Move approved subject to staff
Wait a minute,
comments.
did you want to speak?
Yeah, she stood up.
wanted to clarify one thing.
Sure, come on up. State your name and address.
My name is Jessica Mayer, 6530 East 13th Street. I'm the realtor involved in this transaction. I just want to clarify one thing, that this is not intended for rental use. So I wanted to make that very clear. So, okay.
Thank you. Now, we'll bring it back to the commission.
Motion subject to staff comments. Approval.
Second.
I heard a motion from Mr. McKay and a second from Mr. Johnson. Any discussion? Seeing none, all in favor say aye. Aye. Opposed? Okay, 13-0. I think everybody came back, yeah. All right, item number 7, case number 2017-00039. Mr. Miller.
All right, close enough. Dale Miller, planning staff. This is a request to take a non-conforming correctional facility to a conforming status. As you probably already know, it currently is used as the work release facility. There is overcrowding at the central jail here by the county courthouse. And so the plan is to move the work release folks that are housed in this particular facility to another location, and to then put inmates that they don't have room for in the jail here, and that way they won't have to send them out of town or out of county to another place, which will save time and money for the county. As those of you that have been in Wichita for a long time, it's been some form of a correctional facility for many years, decades. When I first got here in '87, they referred to it as the Pea Farm. I wasn't quite sure exactly what that meant, but the facility will house between 150 and 197 inmates that will all be classified as lower level, medium to minimum security. Obviously, it'll be staffed by 19 employees, 24/7, 365 days a year. The reason that we had to do this conditional use was back in 1992. The city changed their rules regarding correctional facilities and said that if they were located within 750 feet of residential zoning, it required the conditional use. And in this situation, there's a cul-de-sac of duplexes or single-family homes on duplex zone property right here, and that's about 500 feet away. And so that's the trigger. The homes that are across the Ark River to the east, the Ark River is defined as a major barrier, and so they don't count in considering the distance. We went to the district advisory board Monday night, and it was recommended for approval by the district advisory board. We have the undersheriff and the sheriff both here. If you have specific questions, staff's recommending approval.
Any questions?
Dale, you did say that this is a pretty loose facility right now. They're all going to put the fences and everything up to meet the standards of, like, I don't want to use the word penitentiary, but.
I'll let them speak specifically, but there are areas that are chain linked today, and So I'll let them discuss any additional fencing and how those folks would be handled.
There are questions at this time? Seeing none, the agent or applicant.
Good afternoon, Planning Commission. My name is Tanya Cole. I am Director of Facilities with Sedgwick County. To speak to the fencing that we will be using at this facility, it's going to be minimal. What we'll be doing is putting 8 feet fencing around the exterior of the pods, and it will have a little bit of barbed wire on the top of that portion, but that will only occur about 350 square feet around each of those exterior doors. So that's going to be an additional 3 doors. If you drive by the facility now, you'll see that one of those pod exterior doors already has fencing around that. The only other fencing that we'll be doing is on the east entry, where we'll have deliveries and inmate movement. We will put a fence with a gate, and again, that will have barbed wire on the top, but we are not doing any type of fencing around the entire facility. It will just be on those exterior exit doors.
We have 9 more minutes. Any questions? Mrs. Miller-Stevens.
In this facility, will there be full service, like at the regular jail, food service, healthcare, et cetera, or will they have to be moved for those services, or those services imported? How is that handled?
Great question. Colonel Brenda Dietzman with the Sedgwick County Sheriff's Office. What we're intending to do is what we do now with meals, is that we make them at the main facility and then bring them down to the work release facility, or what we'll call the annex. As far as medical, we're looking at that now, and we'll enhance our medical contract so that there are medical providers there. However, if there's a more serious or something that needs to be looked at by a doctor or a PA, they will be transported back to the main facility, so they can be seen under our current contract. The advantage of that is that we're not sending them out to a hospital or other clinics or things like that, so it's actually going to be a savings for the taxpayers in that way, although we will have to enhance our medical contract, which will cost more than what that savings particularly is.
Green.
Yeah, could you define what is meant by low-level, medium to minimum security? What kind of inmates are you referring to at that?
These are going to be people who are there on commitments, so like DUI commitments, traffic type commitments, things like that. We're also going to be looking at potentially other misdemeanors, crimes, nonviolent felony crimes such as forgery, things of that nature.
And then a follow-up, how can you assure, what assurances do you have that only those types of inmates will be visiting that location?
We hope they're staying there. These.
Are you serious?
Maybe I should rephrase that. I assure you that they will be staying there. We have a classification system within our facility, with our main facility, and we actually have corporals and a sergeant that's assigned to our classification unit that specifically look and they interview these inmates, and they actually classify them based on a series of questions that they ask them. So all of our inmates within our facility are either low, medium, or high classifications. So those are the ones that we're looking at. Those are the ones, for the most part, that we send out of county right now, which is what we're going to be saving the money on, because we're going to be drawing those back in. We have a very capable main facility. We just need places for these folks that have these low-level crimes to stay, that are in our custody, not someone else's custody. So we feel a bit safer for that, because they are our responsibility. So we do want them here in Sedgwick County.
I'm glad that you're putting this back to use for I think its original intended purposes back in the day, when it was a huge garden in the area south of the building there. So,
Ms. Miller-Stevens.
Are those that are awaiting trial, will any of those be housed there, or will those stay at the main?
It's potential, because we have both pretrial detainees and then post-conviction inmates. And again, those are all classified. So just depending on the classification, if somebody's awaiting trial on a DUI or, you know, a minor, like a misdemeanor, criminal damage to property, things like that, that would be potentially, depending on some other factors, considered a lower medium classification.
Any other questions? Seeing none, we will go to the audience for anyone that'd like to speak about this project or this zoning case. Seeing none, we'll bring it back to the commission.
Move to approve for staff comments.
Second.
Actually, I had a question for Dale real quick.
Okay, we have a motion by Mr. Johnson and a second by Mr. Green, and now we have discussion, and I think we have a question by Mr. Blick.
I just had a quick question, Dale. So around that property area, most of it looks like an industrial corridor anyways. To the north, south, it's primarily city of Wichita and stuff. Is that correct?
Yeah, their central maintenance facility is all along here and down here. And to the north is an aircraft manufacturer.
Okay, that's my biggest question. I was just wondering, so sounds great.
Any other discussion? Seeing none, all in favor say aye. Aye. Opposed? 13-0. Thank you. Spending your afternoon up there. Yeah, sure. See you. Okay, case number, number 9, case number 2017-00053. City zone change from single-family 5, single-family residential to light commercial, limited commercial, to LC limited commercial on 1.5 acres. And Dave, I guess you're very popular today.
Yes, Mr. Chairman.
There was just a question.
Thank you. This is a request from the Parkview
Just a
Baptist
second.
Church.
You just wanted to
Pardon?
ask a question.
Did we have a question on this?
Yes.
Mr. Foster, that was the one you, is there anybody in the audience that wants to speak to this? Okay, go ahead and ask your question.
Dave, I wanted to clearly understand on the diagram submitted regarding the parking, it refers to access to the site, but then, yeah, right there. If you look at that, it notes that 2 drives are going to be closed, and then there's another one down to the south. And I'm trying to figure out, how is the church going to have access if those 2 drives are closed off? And how does that access work?
Well, I will address that as best I can. We may want to ask the agent, because this is their little submittal of drawing, but the property in question for the zoning change is to the south. And this is indicating that what the church is giving itself as it passes forward is an access easement that will allow traffic to also flow into the parking lot to the north, across lot access as this land further develops. And I think everyone's aware it's Freddie's that's buying the property. And the church plans, as I understand it, to close the 2 entrances now and open up a new one essentially directly across the street from that north access that goes on further west to the south Y. The new lot that will have to be created, and there will be a plat or a lot split submitted, will also have to gain access to Meridian, and it's intended to go directly across from where the current drive goes into the fire station on back to the Alfred Library. But they intend for this to be just access for a cross-lot access. Now, that one entrance will be what the church will use for everything that they do. They'll also be able to, if you're here, float throughout Freddy's if you want to, I guess. But that's how that's proposed to occur. The main point, I think, in this is that you've got 2 driveway entrances off of Meridian that are going to be closed, and now we'll just have one.
That makes me think of 2 questions. One is, please confirm that then the application site to the south will be able to use that drive that's showing on there as their entrance. Is that correct? Just below
They'll
your
have
cursor.
access, yeah, that's
No,
an
just below
easement
your
that would be
cursor.
covered with the cross lot access. When Freddie's or whomever subsequently comes in with the site plan, they'll have a record of cross lot access that will be attached to and move forward with the plating or the lot split requirement. And the site plan will then show, yes, out of whatever they have for parking in this restaurant, they'll have an access to go into that.
But will they also have the access going on to Meridian?
Onto where?
It's not clear that it's going to have access direct onto Meridian.
Well,
Can the applicant answer?
the lot to the south will have a request an access point new at this location. When this lot's created, and city traffic has indicated they'll be okay with that. And then,
This is the final question, and just to confirm that you'll be able to tie the cross lot to this application. And
it
that
will be
it's-
as well as when
application
either the
doesn't need to be
replat or the lot
expanded.
split or the condition of approval will have that, yes.
Okay, thank you.
Any other questions for the presenter? If not, we'll have the owner applicant.
Russ Avey, Boffman Company, agent for the applicant. Stand for any questions. Yes, sir.
So the question I have is kind of falls on the same one. When I look at the site that's down there, and I've been around the site, there's about 300 to 400 cars that come out of that YMCA. So they designed a crosswalk, and they put in a crosswalk that was right there to help kind
Right
of
here.
slow some of that traffic down, correct? So the last two properties that have came down there were Casey's and that are further south, and they have two entrances, and also Burger King has two entrances to kind of eliminate some of that congestion that's happening right there, because it's a growing
Correct.
area.
Yes.
Have you looked at possibly adding this, is the area, will it incorporate, or can it handle two entrances onto Meridian?
Well, quite clearly, you just explained the situation on South Meridian. So we have 33rd Street here. We have the entrance to the South YMCA here, flanked in the most unfortunate existing situation by two entrances for the church itself. We realize that we only really probably have the frontage. We have about 175 to 165 feet of frontage, although we have 4 permitted driveways from this point to this point, platted. We know that we're going to have to work with traffic engineering, so this is the entrance to the fire station and the library that we had our district advisory board meeting at, which they approved this case 9-0. Obviously, just basic design standards would tell you that we're going to have to marry up our primary entrance across the street from this one. In working with the church as well, the city is looking at the potential of adding an additional signalization to either this intersection or this intersection, which would necessitate us closing the 2 drives and, again, lining this drive up with the high traffic openings across Meridian. In no way is this part of the application area. We are simply trying to rezone this application area. This was a simple courtesy exhibit to lessen the confusion on access on Meridian.
The
But it didn't work.
The question I asked is, will it handle 2 entrances or will it not, based off your expertise?
Yes, we could absolutely physically put 2 entrances in and out, but it would be a horrible situation for the fire station across the street.
Okay.
You do not want to have, for example, this intersection and having left-bound, northbound turning movements in conflict with left-southbound movements out of this entrance.
Okay. So you said there's a possibility that your city's going to work with a new light further down. Are they going to possibly take out the crosswalk then?
We have studied this situation right here as the signalized intersection. I think I misspoke. I said this was a possibility. I believe the only consideration for an additional traffic signal would be this location. And then they would probably modify this pedestrian crosswalk with some sort of activated crosswalk system. I don't know. I don't see the city approving a mechanical signal there as well as there.
Correct. Okay, thank you.
Yep.
Russ, thanks for pointing out that the vote by the district advisory board was so positive.
Well, I didn't want to boast, but yeah, they stood and cheered for a while.
Come on, Freddie.
Any other questions for the agent or applicant? Seeing none, we'll go to the audience. Anybody in the audience like to speak?
Anything I misspoke about or anything you want to add?
I assume that's the owner's rep? Okay. All right, well, any rebuttal? Any questions?
Getting late in the day.
Motion to approve staff.
Second.
Second.
They raised their hand, so Mr. Blick made the motion and Mr. Green seconded it. And any discussions?
Yeah.
Seeing none, all in favor?
Girls in there.
Aye. Opposed? Okay, 13-0.
Too far away from him, Cindy. He couldn't understand.
All right.
Second, Joe, second.
Any other matters or to be brought before us? If not, we're